everybody who's come. So you see the title of the program, Environmental Due Diligence in Industrial and Commercial Real Property Transactions and in Corporate Acquisitions. And I put the subtitle, the what, why, and how environmental lawyers and real estate and corporate lawyers work together to benefit clients, for a very specific reason, though it may seem like an obvious subtitle. So I want to explain to you, if you're looking for easy formulas, and language for contracts, and oh God, I hope he gives us the language that we can cut and paste and stick in a contract. I'm not going to do that. I used to do something like that with a sort of an appendix to my talk with sample provisions, but people get locked into thinking there's magic formulas. What I want you to do is walk away with not only the big picture. I don't want you to walk away with anything that's so specific and so narrow and so formulaic that you think that's God's answer to everything. I want you to be able to think about these issues, because you will ask much better questions of your environmental lawyer and your environmental consultant when you have that occasion to have them as part of your transaction. But also, as a threshold matter, I hope that what you learned today will educate you enough to give you a sense of, well, when do I need one? Because it's obviously not every industrial or commercial property transaction that you need an environmental lawyer. You do need a consultant, environmental consultant, let me say, for any industrial property and most commercial properties, but especially industrial properties. But you don't need a lawyer. But I want you to be able to think through the issues and come away with a grasp, because it's very helpful to everybody. All right, so what are the regulatory roots of environmental due diligence? When this program was live, I used to ask people in the audience, well, why do we do phase one environmental site assessments? There'd always be a wise guy or gal who'd raise his or her hand and say, because the banks make us do it. Well, there's a reason the banks make you do it, but that isn't even the principal reason to do it because of the banks. You're doing it because you want to receive the protections of the law, as well as yourself understanding what you're getting into. Because if you have the kind of contract that permits you to get out of the deal, you're the buyer of an industrial property. If you do your phase one and you find out certain things, you might find out things in that phase one that make you think twice. And if you have the ability in the contract to get out of having to close and get your deposit back, you probably want to do it. So that's really the major reason why you're doing it, number one. And number two, you want to acquire whatever legal inoculation you can get against future liability if you do follow through and close on the purchase of the property or the businesses, if it's a set of businesses. All right, so briefly, and I thank Jim, who actually put this together some years back, and I found it very helpful the way he laid it out. Basically, the original Federal Superfund Act, which is what governs what kind of environmental risk you're taking on, either by selling or acquiring the property, that goes back to 1980, the Federal Superfund Act. And there was a provision in there about innocent landowners, and it gave you the benefit then as a defense in litigation, only in litigation, of being able to claim that you did an assessment that told you what was or wasn't on the property from past uses of the property. And so you could actually get a protection as much as anything against the government more than other property owners. That got clarified with the first major amendment to the Superfund Act in 1986, the Superfund Amendment and Reauthorization Act, SARA, that set up what the all-appropriate inquiry standard was. Well, it says left undefined, and that's sort of true, but the basic concept, again, I'm trying to teach concepts. Nobody's going to remember, nor should they remember, specific wording of a statute or regulation, but understand the concept. The concept is that you should do, if you wanted to claim that you were innocent, all appropriate inquiry into the past uses of the property consistent with good commercial and customary practice. That's a paraphrase. It might even be exact wording. So what that all-appropriate inquiry was developed in the environmental consultancy and environmental lawyer community in the late 1980s, and I was part of a group called the Environmental Auditing Roundtable that mostly was not lawyers, Thank goodness it was more fun to work with the environmental engineers like Jim and others to help develop what that standard was. So the concept was, well, how deep do you have to go into the history of the property in order to satisfy this all appropriate inquiry? So your client could say later, gee, I did my due diligence that statute tells me I'm supposed to. So I want to be exempt from liability or at least have a defense to liability. Two different concepts. Most of you are lawyers, so you know that. And so a workshop was created and a private standard setting group called the ASTM, American Society for Testing and Materials, developed in 1993. It took a while, the first standard practice for phase one environmental site assessments. And that laid out what had to be done to constitute an appropriate environmental site assessment. There was also a transaction screen process at the same time, a different number ASTM standard. Sometimes banks use this. Honestly, I think it was a bad idea, or at least it's nothing that has much utility in my view, unless you're doing the quick and dirty and finding out what's in the background of the property. There were a couple of other amendments which we won't go into. The major one between 1993 and 2002 gave certain kinds of protections to trustees and had some other provisions. You then had the Small Business Liability Relief and Brownfield Revitalization Act in 2002. That mandated EPA to come up with its own standards. The US EPA, believe it or not, did not have such a standard. And it added a really, really important provision that's important for our talk today. That it used to be before 2002, when you were about to buy some industrial property with a likely past history, you'd sit down with EPA 2, 3, 4, 5 meetings to hammer out a kind of prospective purchaser protection that would be unique to your property. It's a hell of a lot of work. And I don't know who gave EPA the idea, but Congress passed this provision in 2002 that said, you know what, you don't have to do something particular with each site, and everybody's spending a lot of money having meetings with EPA, and EPA is spending a lot of staff resources. Instead, we'll say that if you do an appropriate assessment, number one, number two, if you don't disturb any schmutz that's on the property when you do find out, you cooperate with the government or with private parties doing a cleanup, and a few other sort of due care, as I think they were generically called, due care provisions, you will not get just a defense, the old defense to liability. Better than that, you'll be exempt from liability from day one. That's a pretty cool thing. And so if you really want to know, what's the ultimate reason that you do the phase one environmental site assessment, beyond wanting to know about the history of the property, you'd love to get this for your client. Your client would love to be absolutely exempt from Superfund liability, so long as it followed all the rules, not just do the phase one. That's the threshold first thing you have to do. But this due care requirements and all the litigation on this provision has all been whether a party that acquired contaminated property in fact observed all the due care requirements. And to take an obvious example, if the contamination is just in soil in the northeast corner of the property, and that's where the buyer, the developer of the property, wants to build, so he gets a backhoe and says, oh, I got to level it here, and he moves the contaminated soil from the northeast corner of the property to the rest of the property. Well, guess what? He's lost his bona fide prospective purchaser exemption from liability. Going into more detail perhaps than you want to know, but I want you to all have a really stronger feeling than you had before today of why you do this. You don't just do it because banks require it or because the law requires it, but because the benefits are so enormous to your client from doing it, when your client is the purchaser, of course. It took only 2 or 3 years for EPA to come out with an all-appropriate inquiries definition. And it's more or less consistent with the commercial standard, the American Society for Testing and Materials standard, which itself went through some changes from the original one in the early 90s to one in 2005. Might even have been one in between, I don't remember. And then it was revised again in 2013. And then It was revised again in 2021, although it didn't become effective till just 2 years ago. And we'll go over a couple of, not in a lot of detail, but over some of the differences in the definitions, because again, only to the extent they help you sort of grasp what's going on and ask the right questions of the environmental consultant and or environmental lawyer, because that's the way you real estate lawyers, those of you who are real estate or corporate lawyers, this is the way you can protect your clients. And that's what we're trying to do is today is help you protect your clients. Okay, so why do we do it? We've actually talked about most of this. How do you do it? Why do I need another lawyer in this transaction? I used to hear this in the 90s in private practice. I hear this in the 90s, especially if the real estate lawyer was at a small or medium-sized firm and the client, was already spending enough for the real estate lawyer. And God, why do we have to have another lawyer, whether in that real estate lawyer's firm or outside? And can't I just, I being in this case, well, either the client or the real estate lawyer, why can't I just order a phase one environmental site assessment myself? And that does happen. Not the best of practices unless your consultant is good about letting the client know, you know what, you really need for this project, based on what we're finding in the record of the property, you need an environmental lawyer on this. So the rest of these, as I say, are pretty much, well, how do you do it? And there's two components. There's the contract drafting and the site assessment. And ideally, you real estate lawyers or corporate lawyers, you want to get, you really want to get the environmental lawyer on board for the contract drafting. Even the best of the real estate and corporate lawyers I know and work with know that they really don't know how to draft these provisions. They might use an old one from a contract 2 years ago, probably okay. 5 years ago, 10 years ago, forget about it, because there'll almost always be some case law in between or some changes in statutory provisions, whether at the federal or the state specific level, that you want to change the language. So you don't want to use old formulaic provisions thinking, well, some lawyer at some point in the past said this was a good way to deal with this issue. But if you're not thinking through the problem to some extent, and these are risk problems, you don't have to understand, technical issues about whether, thresholds for cleanup are being met. You leave that to your environmental consultant and environmental lawyer to tell you, but you want to think through, how is this a problem for my client? And that's why you want to have the contract, make sure that the contract's expressing what the business deal is as far as the allocation of liabilities. And so there's the contract drafting and the site assessment. So in the contract, you need proper reps or representations, warranties, covenants, and sometimes indemnities. And as I say here, and I'll try to not repeat it anymore during my talk, forms won't do it. It's possible that the original form used 5 or 10 years before is still okay, but becomes less likely with the passage of time. Context is everything. What are the parties trying to accomplish? Again, it's not, one size fit all. There's so many things going on in the dynamics of the business deal. And you as a real estate lawyer, you're probably very aware of how to incorporate that into your drafting of the real estate provisions, less knowledgeable about how that affects the environmental provisions. And I often think that's mostly what I do, is make sure I really understood what the business terms are. And before the contract gets finalized, I'm involved in the drafting of those provisions. Sometimes it's a half a dozen or more provisions, not one or two. It's usually half a dozen or more provisions that concern the environmental issues. And so that's what we do in the contract side. And then the site assessment side, though, if you're lucky enough to have a great consultant like Jim Cinelli and his crew at Liberty, they'll do a wonderful job. Their actual site assessment won't need much lawyer input. But again, I want you to understand the concept, you who are attending today, that you're trying to establish the baseline property conditions and you're doing other things, but these are the two principal things: establish the baseline property conditions and plan how to remediate and otherwise deal with any problems that you're going to find. So I'm going to go over this part sort of lightly. This is just an overview, and Jim's going to get into this in much more detail. But the phase one, it's a paper exercise. There's no samples of groundwater or soil vapor taken. It's a site, there's a site reconnaissance, but a lot of it is done on paper or electronically through database searches. There are packages that the environmental consultant buys that include historical research, aerial photos, sandborne maps, and Jim will explain more about that. And of course, deeds to the property. You want to understand the property history because you want to know who was operating what kind of business on the property, going back pretty much as far as you can in the development phase of the property. That might be only 30 or 40 years ago, more likely to be 60, 70, 80 years ago. And sometimes, as in the case of New York City property or other industrial areas, you've got maybe 150 years of some kind of industrial history where it's likely that something was left on the property, released onto the property. You certainly want to look at the files of the appropriate environmental agencies, although very often the phase one is completed, at least in draft, before you hear back on a Freedom of Information Act federal level, or depending upon what state, it'll be called something like FOIL or Freedom of Information Law in New York State, for example. That's important to see from those agency reviews. But you get most of the stuff from the database reports. And then if there are any liens on the property relating to environmental conditions, which occurs more and more often as risk-based site cleanups have taken place on more and more and more environmental properties over the decades, that means you have a lot more properties where there's either a lien or something else that you'll find in doing a property search that will tell you some limitations on how you can use the property. It might tell you it might indicate that there is something called a site management plan, which means a plan for how to use the property in the future and develop it, and whether there are restrictions that you need to know about. Because the flip side of risk-based cleanups being more efficient and cost-effective and cheaper than the old, one-size-fit-all cleanup is that there might be something in the future that has to be done if what was a warehouse is going to become, an apartment building or a nursing home or a daycare center. You might have to do more cleanup, but you want to see what's in the file. All right, so we talked a little bit about this, why site assessments are necessary. What's the scope of liability under the Federal Superfund Act? It's the present and past owners and operators. Now, it's a little condensed the way I put it. It's present owners and operators. Okay, so operator meaning a tenant, if it's a commercial industrial tenant. And they will have liability. The owner especially will have liability as a present owner, even if he or it has been an owner for only a year or two or three. That party will have liability for contamination that was released at the property 10 and 20 and 40 and 60 and 80 and 100 years ago. Even though it looks like a retroactive liability, it's been upheld by the courts long since, back in the 80s and 90s, a lot of litigation about that. So you will have as a present owner, you'll have that liability going back. How about past owners? Some of you who have been practicing real estate law for a long enough time, will remember a concern for some years, typically in the 1990s or so into the early 2000s, a fear that anyone in the chain of title might have liability. It's no longer the case. A past owner has liability for what's there now only if the release of contamination occurred during that window of ownership. That might be 1 year in 1995 when your client's company owned the property, but had a tenant whose operations, from an historical review and piecing together other information, you can say, you know what, that's when the release occurred in 1995, not 1994 or before, not in 1996 or after, just that 1 year. Unfortunately, your client owned the property at that time, had a commercial or industrial client that released some contamination. So a past owner at the time of the release, transporters and arrangers will have liability too. So if your client is a trucking company that brought wastes from the ABC Chemical Company, just made up that name, of course, to the property in question, there will be some liability because that action, that activity of another party, not an owner of the property, never an owner of the property, but who transported to the property and created a contamination situation that didn't otherwise exist, that party will have liability and arrangers for transportation. So that would be, of course, in my example, the ABC Chemical Company that picked up the phone, called its usual truck transport company, and had them take wastes and bring it to the property in question. Happens all the time. So all appropriate inquiries, as I explained before, into prior uses of the property consistent with good commercial and customary practice. We've talked a little bit about bona fide prospective purchasers, and that's that exemption from liability that you want to get for your client. All right, contract of sale, what do you need? This is an overview. Again, I used to give a lot of definitions. I'm only going to have a definition of the last of these because it's the one that people are sort of least familiar with. But let me go through this because, again, I want to give you concepts. Okay, hazardous materials. Well, what does that mean? Why is it material? Why isn't it substances or waste or something like that? And the reason is that you want a definition of hazardous materials, irrespective of what federal or state law is being invoked to make it hazardous. Okay, so the federal Superfund CERCLA talks about hazardous substances, which includes lots and lots of things, doesn't include petroleum. Guess what? You want to include any kind of petroleum products. And why is petroleum not included in hazardous substances or hazardous waste? Can you guess why? Well, the oil lobby has always been very strong, and at the time of passage of Superfund, they were really strong, and that's why it got out of there. But hazardous materials, as a commercial definition, includes hazardous substances, hazardous wastes, and that comes from another federal program, the Resource Conservation and Recovery Act for active facilities, and petroleum products. So that's why you have a broad definition. I put in this, just working on these slides last week, complete sites, better as amended versus broader, or can use no site. I can't tell you how many times a corporate or real estate lawyer has presented me with a draft contract, and it'll mention the original CERCLA from 1980 and give a citation, and then it'll say, as amended 1986 Superfund Amendments and Reauthorization Act, and it won't say anything else. It won't say any other amendments. And, Law School 101, I assume everybody or almost everybody on the call is a lawyer, but Law School 101 is, if you include some amendment or amendments, but not all of them, the intention appears to be that you're excluding the other amendments, which you don't want to do. So I tell, to the amazement sometimes of real estate and corporate lawyers, I say, just put as amended. Don't put a specific amendment, because then you got to put 4 or 5 significant amendments. Just put 42 USC 9601 at seek, comma, as amended. And then you're good. So that's just, again, I want you to think about that as opposed to saying, Periconi says this is the rule, but think about why you would do that. And that as lawyers just in your other practice. Environmental requirements. Why requirements? Why not laws? Seems strange to use a sort of a non-legal word like requirements. Again, conceptually, the reason is that both at the federal and state level, environmental agencies, because of the complexity of promulgating regulations, public notice periods and comment periods, a lot of time environmental agencies do the quick and dirty. Quick and dirty is they come up with a guidance, capital G, a guidance or some other, or a commissioner's memo or one term or another to describe something that is not a law, so it's not a statute or a regulation, but it is a requirement, and you will be guided, and your client will be guided by it. And it might say something that's a bit of a stretch from what the regulation actually says. Or it'll put more flesh on those bones, because regulations, which are supposed to flesh out statutes themselves, don't always flesh out statutes as much. So that's why we say requirements, not laws. Again, think about that conceptually and it'll make sense. Claims, I'll go over this in a few minutes when I get to what's an appropriate standard by which a buyer can get out of a contract before closing as a result of its due diligence. You don't want any violation of the law. I can't tell you how many sites where there is contamination. I could pick out a particular one like trichloroethylene or BTEX, which is the components of petroleum, and the standard might be, I'm just going to throw out 10 parts per million, and the buyer's been able to do not only a phase one, but also phase two, get some samples, and shows, oops, there's 12 parts per million of something that, anything above 10 is a problem, is a violation of the statute. Well, you know what? If you're the seller, you don't want the buyer to be able to get out because of that. Anything that's an exceedance of a standard, which would appear to violate an environmental requirement, arguably, it's got to be meaningful. It's got to be able to give rise to an environmental claim. And that's why we put that in. Do I succeed in getting this in all the time when I'm representing the seller and I want to make sure the buyer can't walk away too easily? No, but I always try to get it, and you should try to get it, or get your environmental lawyer to try to get it, because you don't want a buyer getting out of a deal, too easily without cause. So, and then material adverse effect. It's the only one I'll give you sort of a shortened version of it. It's really not that. I just put this in a couple of days ago, and I thought, I'm not sure this is helpful at all. But this would be in corporate transactions. Typically, a threshold for some consequences will be that there is contamination that could lead to a material adverse effect, and it's kind of fulsome in a bad way, but basically any circumstance, event, or effect that could have a material and adverse effect, which of course is tautological. It's because it's incorporating the title of the definition into the definition. That impacts the ability of the owner or seller to consummate the transaction. So it's a bit of a standard. You can't straight-facedly say, as a prospective owner, that on a $10 million property transaction or a $50 million business transaction, a corporate transaction, you can't say that a problem that's going to cost $5 or $10 or even $20 or $25,000 is going to have a material adverse effect. There's a common sense standard. Certainly, my private equity and other corporate clients will already have defined for the environmental consultant what is a material, potentially a material adverse effect, or similar terminology with the word material. They'll define materiality, and it's often at a level of like $50,000 for any one particular problem, whether it's a contamination issue or an environmental compliance issue, which is more the problem with the corporate transactions. So, but just to give you some idea of what's included or excluded, again, if you use any good environmental lawyer, he or she will have standard provisions, but they're thinking through, is this standard provision or is there another one that's appropriate for this deal? So again, there's not a lot of point in my giving you the language for these provisions. All right, so representations and warranties. Again, those of you who are real estate lawyers, you'll know what a representation and a warranty is. A warranty is a promise that the representation is true. The representation is a statement of fact about the condition of the property. Lots of provisions, lots of real estate contracts, of course, there'll be no representation about the condition of the property, and that'll be explicitly stated. And even if you've got strong representations and a nice warranty to back it up, you still want to have an indemnity provision, and you still want to have an environmental assessment. I've actually had some prospective clients who are in a real hurry to close a deal, and They want to close in 20 days from signing the contract, so not even enough time for phase one environmental site assessment. I tell them the manifold reasons why it's a really bad idea. Oh, but I know the buyer. I've worked with this buyer before. I don't have to worry about him. Terrible idea. I actually have a case like that right now, where the client, we're far enough away from the contract that the client forgets that he didn't take my advice on certain provisions allocating the liabilities between the parties. And now we've got a bit of a situation where there might have to be some future work, some cleanup. And the client says, well, of course the buyer's going to take that on. And I say, no, that's not what your contract says. Maybe you're friendly with the buyer. But if I were representing the buyer, I'd say, sorry, Sam, you guys are good buddies, but the contract provides for you, the seller, to pay for this work has to be done. So anyway, you want to be careful about that. Some examples of representations are the usual, starts off with the usual real estate representation about, the inducement to purchase the property, in what the knowledge that the buyer has or has been provided information to have knowledge. And then you can have different qualifiers or qualifications. For example, if I'm representing the buyer on a transaction where the seller says, seller has no knowledge of any environmental contamination, blah, 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 blah. I always insist, I say, well, I don't know if that just means the principal. And does it mean the principal, if he's like sitting around having a cup of coffee, does he remember this contamination? So you want to define what the level of knowledge is. And the thing we usually come down to is after review of the files, because if a seller is required to look at the files, assuming he or she or it has enough integrity to actually look at the files, you at least want to get that put in. A representation as to whether there are environmental violations and that the property is or the business operation is in compliance with laws. We'll very often get that representation. It shouldn't be that hard for a seller if the seller has looked at its own files and found out, gosh, do we have any current violations that we haven't addressed, so forth. Another representation, especially for an operating entity, is does it have all the required permits? That's on a property that has permits. More on representations and warranties, it might be that there are no hazardous substance, hazardous materials, or hazardous operations. So what are some of the issues that come up? Well, how about de minimis, knowledge of de minimis hazardous substances, et cetera? You go back and forth on whether that might be appropriate. More to the point is, how far back in time do you, as the buyer, want the seller's representation to go? Is it just during the seller's own use and knowledge of the property or ownership of the property, or do you want to sort of pin on the seller to go back a little farther in time? Because after all, the seller at some point did its own due diligence, especially if it bought the property in the 1980s or later. So not only a representation about there being no notices of violations, that's what the notice there means, or reasons to expect one, because many property owners know they have a situation on their property, whether contamination or other issues, that would constitute a violation if a regulator ever came around, but the appropriate regulator hasn't come around to find the violation. So you want to have the representation include no reason to expect one. Sometimes an owner/seller will squirm at that request, but that means that it's usually uncovering something that you want to know. There are tricky issues with asbestos and PCBs because there's different definitions. Lots of state environmental statutes are the state counterpart of the federal statute under the same state regulatory program that mimics the federal program. But on some things, that's not the case. Like PCBs are regulated in New York State, for example, under our state version of RCRA, Resource Conservation and Recovery Act. But in the federal law, not under RCRA, it's under the Toxic Substances Control Act. And so you got to be aware of that. And if you think that any of these things are problems, asbestos definition is different in New York City from New York State and the federal. So these are again, I'm trying to just alert you to where there is a problem. All right, as is clauses. This is where you really want to pay attention to what's going on. So this, as a business matter, the sale might be an as-is sale, which virtually all of you know. What that means, meaning it means conceptually that the seller is making pretty much no representations, at least on the environmental side, about the condition of the property, whether for environmental contamination or for whether the property is suitable for use for some particular future use that's different from its current use. And there'll usually be a phrase that the buyer has inspected, or if the buyer hasn't inspected but had the opportunity to during a due diligence period between signing the contract and closing, the buyer just decides for some reason not to inspect. You as the seller don't want the buyer coming back to you a year later and saying, "Oh, we didn't have time to do an inspection or do phase one," and you as the seller say, "But you've signed this provision that says buyer has inspected the property." The buyer says, "I didn't inspect it, so therefore this provision is wrong." That's why you, as the seller, want to make sure it says buyer has inspected or had an opportunity to inspect and investigate, etc. These are little things, but again, here's what I want you to come away with today. If you're buying the property, if you're representing a buyer of the property, and the seller gives you a draft contract with an as-is clause that's this long, or even this long, or even this long, you know it's missing some things, okay? So a general release or shifting of liabilities from one party to the other, it's got to be really specific. You got to be really clear. Are you trying to shift statutory liabilities as well as simply doing it contractually? So there has been case law, not in New York State, but in other states in the last 20 years, where court has said, there's a shifting of liability, but it doesn't say that CERCLA liability was shifted. And that's a very specific statutory. CERCLA is the acronym for the Comprehensive Environmental Response, Compensation, and Liability Act. You'll see it later. Don't worry about writing it down. CERCLA, or commonly known as the Superfund Act. It didn't shift CERCLA liability. Therefore, we, the court, say that the liability for Superfund liability was not shifted to the other party. And actually been a couple of decisions that have said that. So this is where you want to be pretty complete about your listing the statutory regimes that are being shifted from a likely owner, likely because of either statute or common law. The owners of property, if the release occurred during the owner/seller's period of ownership, if the contract's not real clear, under common law, the owner still has some liability. So the owner wants to make sure that the language is clear. Buyer also, everybody's got an interest in making sure that it's super, super clear what liabilities are being shifted, statutory as well as being shifted contractually. All right, I see that I'm not halfway through my slides, and I am more than halfway through my time, so I'm gonna have to move a little more quickly. And
all right, before we move along, I'm just going to give the first code word for today. As a reminder, this is 2 credits. The first code word is environment. The first code word is environment. I will type it in the chat. Thank you.
Thank you, Diana. All right, pre-closing covenants. Typical will be a covenant by a party if there's some contamination issue that hasn't been fully addressed. A lot of times buyers will ask for, and depending on the situation, the seller may want to give it into this request that the seller obtain a no further action letter or some equivalent to it, typically to close some inactive underground tanks that are still around. This can mean a delay till closing, especially if there's some remediation that's needed. But these are things that a seller ought to have taken care of out of prudence, not because the law was there, but out of prudence. But they somehow stopped using some underground tanks that had petroleum in them. Maybe it's fuel oil tanks or heating oil tanks, or fuel oil, gasoline for trucks or whatever. And this will delay the closing. But so you'll have covenants, not always, but sometimes covenants being promises to do something specific. You'll always want, of course, a maintenance of the representations. So the seller is going to keep the property. Not only is the property in compliance with all environmental laws at the time the contract is signed, but if you're representing the buyer, you want to make sure that there's a maintenance of that representation through to closing, especially a closing that's going to take 60 or 90 or 120 days to happen. Or you want a reaffirmation of the reps and warranties. This is good general practice. It isn't really specific to environmental provisions. All right. Indemnities, you guys know this from real estate provisions. It's a full and complete shifting of liability. Typically want to have a separate standalone environmental indemnity rather than mix it into any other indemnities that might be there. And there's some more detail here. Again, I'm trying to be mindful of the time. It should be, on the other hand, should be harmonious with the non-environmental indemnities. As the buyer, you want to ask, didn't mean to do that. Will you share the contract of sale by which you bought this property, just in case? Because sellers of property don't really remember, especially with the passage of time. They don't remember what was in the old contract. But there might be some pre-existing indemnity that the seller took on or didn't take on, and that the prior owner took on when the property was bought. And maybe that contract helps define whether a subsequent owner can get advantage. This may seem picayune, but it's sometimes not. I'd say 1 case out of 10, this comes to be of some importance, or at least some interest to helping negotiations for amendments and that kind of thing. The impact on statute of limitations: an action for a breach of contract for failure to comply with a representation or warranty will run from the breach of a warranty, but actions for breach of an indemnity run from a later point in time, from the date the party fails to meet the obligations to indemnify. So it's more protection for the indemnity if you have the indemnity, as opposed to not having an indemnity and just rely on breach of contract. So you see what for obligation. These are relatively minor things. Obligation to defend. The indemnitor might actually want that obligation to help control costs, especially if it involves some remediation that could be fairly costly. You'd rather pay the few dollars you have to pay for a lawyer of your choosing as the indemnitor, rather than say, we'll pick up the lawyer's fees for the indemnity. To the fullest extent of the law, this is because of a New York Court of Appeals decision slightly before COVID, I think, that basically an indemnity that tries to do more than it's able to do can be voided in its entirety. So you always want to add this sort of suffix phrase to the fullest extent of the law to any indemnity, as a way of ensuring that the whole thing isn't thrown out. Again, financial assurance mechanisms to back an indemnity. As you all know, many times sellers of property, if the principals are, reaching a certain age and they're going to retire to Florida with their money, what good is the indemnity being given to the buyer if there's no money left and you can't find the party and there's no money? So you will sometimes want some kind of financial assurance mechanism to back up the indemnity, like an escrow fund, in appropriate cases that makes sense, where everybody can agree there's a problem that has to be fixed, but everybody wants to close on the deal. They don't want to wait 6 months or 12 months for the remediation to be complete and the government to sign off on it. So you put in an escrow fund. All right, walkaway provisions. This is where the specifics of the definitions come into play. So here's as I say here, the clearest is the best. The pre-closing environmental site assessment contingency is something like this. If the environmental site assessment reveals the presence, not the likely presence, but the presence of hazardous materials on sale property or adjoining property in violation of environmental requirements so as to have caused or be reasonably likely to cause environmental claims, then the seller must remediate or the buyer may terminate. Buyers like to keep this provision vague. If the results of the phase one environmental site assessment are unsatisfactory, as a seller, you should never agree to that, because obviously this becomes just an excuse to walk away from a deal where some vague reference to environmental gets mentioned. So the alternative is the parties may wish to specify a de minimis level of cleanup costs before the buyer can walk away. That can be a good way to do it. Existing environmental documents, the seller must provide to the purchaser, helps the seller organize what it has knowledge of. We talked a little bit about this before. And it's really better for everybody if you can say that as the seller has no knowledge of any environmental contamination except as may be described in the documents set forth in appendix such and such. And that's good for everybody because it protects the seller from any later claim of fraud that, oh, you didn't tell me that there was such a problem. Well, we said the representation is except as to what's revealed in these documents. You should have read them. It also helps the buyer in a big way, because it helps the buyer's phase one consultant know as quickly as possible what's out there in terms of past environmental reports or environmental site assessment. Saves time in preparation of phase one. Just you get a better product out of it. Pre-closing cost sharing provisions, typically because the risk being taken on, again, it's a timing issue. The parties both want to close before anybody can even know. They know there's some remediation that'll be needed, but it's too early to have fully delineated the scope of the contamination, so you can't put numbers on it. You've done a phase two investigation, which clients wrongly almost always think, oh, this is going to tell me how much it's going to cost to fix problem. And as Jim can explain better than it won't do that. It doesn't fully delineate the problem, it just tells you there's actual contamination there. Other ways of capping the amount of the seller's exposure, insurance cost cap coverage. I made a change to this slide last week. Beware empty promises of coverage. I have gotten to the point I don't trust underwriters at all. We have a case now with we had a very good environmental insurance broker, and we thought we had a policy that was going to cover a risk that we all talked about, and the underwriter knew about as a potential risk, had to do with retained offsite liabilities. And the underwriter came up with a BS argument to decline coverage. And I said to the broker, I said, I like you as a person, but honestly, I don't think I'm ever going to buy environmental insurance. And he said, we've stopped. This broker, well-known broker, very good one, has stopped giving business to this particular underwriter, whose name I won't mention because they'll probably sue me for libel, but absolutely broke their promises as to what they'd cover in a completely BS use of an exclusion from coverage. Absolutely BS. It's take too much time to go into it. But anyway, it makes me very wary about insurance. You document every conversation you have with an environmental insurance broker, and the broker has to document every conversation, not just emails, with the underwriter. Otherwise, I don't trust environmental insurance for the paper it's written on. That's how discouraged I've become over it. You all talked about this pretty much. Jim's going to go into this in a lot more detail, what this means. But basically, your phase one is an information gathering site visit by the consultant. It's really one visit. I don't know why I have plural there. But the result is to come up with a definition of recognized environmental conditions. And and I think this is the current one, this changes every few years, the presence of hazardous substances or petroleum products in, on, or at the subject property due to a release to the environment, or the likely presence of the same thing, hazardous substances or petroleum products, in, on, or at the subject property due to a release or likely release to the environment. Jim, let's see, when you come up with, you have the same slide. I feel like there's something missing from that, but I'm not sure what it is. Third is the presence of hazardous substances or petroleum products in, on, or at the subject property under conditions that pose a material threat of a future release, meaning there hasn't been a release, but there's a material threat of their future release. For example, it might be something in the database that shows that there are X number of underground storage tanks, of which there's no record of them ever having been decommissioned, or being decommissioned, it's not clear whether they were removed. And an old underground storage tank is probably, Jim can confirm this when he talks, is likely to be to constitute a material threat of a future release. So examples of wrecks are underground storage tanks, buried drums, or waste on the property, leaks and spills, oil staining. Some discretion has to be exercised. Jim does a great job of explaining, this shorthand that I'm giving you. Jim will explain better what that might be, but this is some comparison with the older version. Not that important, really. Phase 2 is your first time. Again, Jim will give more on this. It's the first time you have a real invasive investigation of recognized environmental conditions. Really important. If you're a seller's representative and the buyer says, I want to put in this contract that I can do a phase 2, you say no. I'll put in a contingency provision that if the phase 1 shows that there are recognized environmental conditions, then you can apply with your work plan, which we might or might not approve, we, the seller, might or might not approve, to do a phase 2. And you just insist upon it. But so many times buyers say, well, everybody knows there's a problem on this property because they used to have a such and such operator. Well, that's not enough to give you, buyer, right in the contract from the get-go, the right to do a phase 2 and put holes in my client's property. And then you might, as a result of the sampling that you take from soil or groundwater or soil vapor, decide you don't want to buy the property. Not only do you have to restore the property to the pre-existing condition, but I don't really want that, I don't want that as a permission from the get-go in the contract. You've got to show us that your recognized environmental conditions demonstrate the need for it, and we have the right, seller, to approve or not approve the work plan that investigates those recognized environmental conditions. And then you can put whatever qualifiers you want about, reasonable discretion, blah, 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 to approve or disapprove. The bona fide prospective purchaser, all appropriate inquiries, as we've talked about, appropriate care with regard to hazardous substances found at the property by taking reasonable steps to stop, this is fleshing out what I said before in shorthand, to stop continuing releases, prevent future releases, and limit exposure to released hazardous substances. All of which is obviously violated if you willy-nilly send a earth mover out there to move stuff around to level out the property before you've done a full investigation of the contamination and plan for remediation. So that's why this appropriate care or due care. You need to cooperate with response authorities. That's a way of saying the government, federal or state, that's looking into the issue of contamination there. And information requests, you have to comply with land use restrictions. Institutional controls may well include a site management plan, which usually has an excavation work plan requirement, meaning you can't do anything that resembles excavation, which everybody developing property is going to be doing to one degree or another, without giving us, the agency, your excavation work plan in advance so that we can determine if you're going to touch on any of the crap that's in the ground and move it around willy-nilly. Yeah, person not potentially liable or affiliated with contractual related to any other person. Sorry, that's a little too shorthand, but basically it means that you can't get the benefit if you're the son of the owner and the son is nominally buying the property, you can't get this protection from liability that your father, who had been the owner for years or decades, had by claiming I'm a bona fide prospective purchaser. So you can't have that close affiliation. It's really for arm's length transactions. Jim, don't worry, I'm going to finish up in 2 minutes. Compliance audits, it's another thing not for today's discussion, but that's an in-depth examination of the facility operations. It's much more involved to show whether the company that's operating there has been in compliance with the environmental laws that affect it, environmental health and safety. Sometimes it can be integrated. The consultants choosing a consultant, defining the scope of work, regular contact, don't rush the project process. Yeah, I mean, this is, good common sense. Don't hire an environmental consultant because you found them on Google. Get a recommendation of a consultant who environmental lawyers use in various projects, the way I use Jim in lots of projects. And I use other consultants too, of course. But you definitely want a recommendation. You absolutely don't want to work with environmental consultant. You don't want to pick the consultant who's the cheapest. That's you might get a cost-effective, high-quality consultant that is one of the better priced ones, but you don't want to go just by price. Reporting oil spills to New York State, it's kind of tangentially related to what we're doing, but sometimes that's an issue in the transaction where the seller doesn't want the buyer, if the buyer finds out that there's been some oil spill that needs to be cleaned up, the seller doesn't want the buyer to independently be able to call the state agency, especially in New York, and tell them about this. So you negotiate this. It's not always a concern. This is more about chemical bulk storage and what the thresholds are. They're federal requirements, but they're typically much higher thresholds. All right, so the conclusion here, use competent environmental professionals to prevent the acquisition, if you're representing the buyer, of course, of unnecessary liability. Sellers also, I should fix the slide because it's to prevent retention of unnecessary liability. So I got to fix the slide to reflect that, because what I'm giving you, is advice for both sellers and buyers. You want good contract drafting, good environmental site assessment, and that gives you a deal that reflects the actual business expectations, minimizes later litigation. I mean, I'm happy to say in, I don't know how many years, 30 years in private practice, I've never had a deal that came back to bite the parties later because something was not clear enough in the contract about who had what liabilities under what conditions. So that makes me happy. Anyway, Jim, I've given you now have whatever you have, 45 minutes. Thank you.
Sounds good. Should I just have one question? You want me to hold that to the end or ask?
Hold it to the end because I took a little too much time and I want you to have enough time. Thank you.
Okay, Jim, you need to stop sharing so I can
yes, sorry.
Share my slides.
Yep. There we go.
Great. And make sure I pick the right screen here. How's that looking, Diana? Oops, sorry. Forgot to hit share. How's that looking?
You're good.
All right. Great. Thanks very much, Jim, and happy to be here, everyone. I'm like Diana said in my bio, I've been doing environmental due diligence investigations and cleanup for a number of years. And in addition to covering what we consultants do when we're performing a phase 1 environmental site assessment, I also have some slides here that describe, with some good pictures, what we do when we're doing a phase 2 investigation. If we identify a recognized environmental condition and in a phase 1, we're going to recommend that condition be investigated in phase 2. So I'll get into that a bit as well. And then finally, as a extra added bonus, if you will, because there's something very unique in New York City called the E-designation program, which is a mandatory environmental investigation and cleanup requirement for any tax lot that has an E-designation on it. I have a few slides at the end to cover that. I think many of the presenters, do work in the city. So when I give these environmental due diligence presentations in the New York area, I typically include those slides. So let's move on. The goals of the phase one environmental site assessment, like Jim said, to ensure there's liability protection under CERCLA to perform all appropriate inquiry. We need to identify and explain recognized environmental conditions. I'll get into the definition of that, and something that's less important but is also part of the phase one ESA standard is BERs, or business environmental risks. And real briefly, business environmental risks are almost never something that needs to be investigated. They are simply something that the user should be aware of. For instance, we found an above ground storage tank. It was in good condition. There is no material threat of a release, but as the property owner, you need to know that if that tank is not managed appropriately in the future, that there could be a release from it. So that's an environmental business environmental risk, something to be mindful of during management of the property. What I'm going to talk about for the rest of the presentation is just recognized environmental conditions, or RECs or RECs. And then also, a goal should be a professional evaluation of the significance of RECs and BERs with appropriate recommendations. Different lenders have different policies for this. Most lenders will say, leave the recommendations out of the report, but we want to see them in your cover letter. Also, some banks will want us to weigh in either in a prescriptive manner, low, medium, high risk, or just provide, based on our experience, the significance of RECs that we've found. By their very nature, some we issue extreme caution. Yes, this could be a major environmental issue, but others we know from experience would be a relatively lower risk. So a lot of times we're asked to opine on that by whoever is requesting the phase ones. And by the way, when we're doing phase ones, it's probably 90 to 95% of the time we are retained by the lender. Which is why I talk about the lenders a lot here in the next slide. What do they want? They want to know, this is collateral for a loan, the real estate. So they want to know if our environmental conditions that we identify would negatively affect the value of the property, or negatively affect the ability of the property to be operated as intended. Let's take one example. There are times when we find there's a comment. Somebody had a question in the comments. What do I do if there's a gas station across the street? If you're in an urbanized area and there's public water, and you're never going to put a water well on your property as a water supply, a lot of times a lender will say, you know what, Jim, thanks for identifying this REC, but I don't really care if there's groundwater contamination on my property coming from offsite. And Jim, you can chime in on whether that's wise or not, but a lot of times lenders are saying that. What they will say though is, we want to know if there's vapors getting into our building.
Yeah, I was just going to say that. Yeah, they may not be drinking the contaminated. Sure. Yeah, but vapors, yeah.
Right. If there are vapors entering the building, suddenly it can impact the use of the property. If I can't occupy the basement, or if vapors are getting into the first floor, groundwater contamination is not going to affect the future use of the property. So I'm just this is not from the ASTM standard, and it's not from the AAI rule, but this is just from our experience working with lenders.
Jim, can I just add a quick thing?
Absolutely.
Third really important reason in lenders' minds is, if the new owner is going to have to spend a lot of money doing a cleanup, it impacts their ability to pay back the loan. And that's yet another reason why it's of concern, and it's distinct from the ones you had.
Good, very good point. Yep. Now we're talking about the ASTM Phase 1 Environmental Site Assessment Standard, but it's good to understand that if there's some other loan coming from the Small Business Administration or HUD, they also have their own standards. Typically, they're very similar to the ASTM standard. They might add additional items. They might say that we also want you to include some non-scope items. Could be mold, asbestos, lead-based paint, things like that. Other times they'll say with Small Business Administration, depending on the NAICS code, that's the industry type. Well, we might first do just a visual assessment and an interview, and then depending on what you find, it may go to a full Phase 1. So this is really just a caution that if there's different types of lending from federal agencies, the Phase 1 scope of work might be tweaked a bit. This is right, Jim. You borrowed this slide, and these are really the basic components of a Phase 1. It is not intrusive. It is a site reconnaissance. We're doing a visual inspection. That's all. We're not drilling. We're not cutting holes in walls. But we are performing interviews, and we're doing historical research, old aerial photos and old Sanborn maps. And just to show the value of these historical maps, I have a couple here. Plus, I'm just the kind of person that loves old maps. I have circled here a couple of spots on a fire insurance map. It's the company's name is Sanborn, and these maps go all the way back to the late 1800s. And you can see I identified these two properties as having been filling stations, and it even gets down to the detail showing on each of these properties 3 underground gasoline tanks. This shows an old gas holder and a manufactured gas plant. Manufactured gas plants created coal tar, which can cause very substantial contamination and have very high cleanup costs. And then finally, this is my last Sanborn map. This is an old paint factory where they manufactured varnish and paints for 100 years. They stored solvent in tanks. They stored different oils in tanks. So these are enormously helpful when we do our Phase 1s. So a recognized environmental condition. Jim, I do think you had the correct wording here, and this did change a couple of years ago. They tweaked the definition. And it's the presence of a hazardous substances. Hazardous substances are defined in CERCLA or the regulations promulgated thereunder, or petroleum products in, on, or at the subject property due to a release to the environment, or the likely presence of this hazardous substances or petroleum products in, on, or at the subject property due to a release or likely release into the environment. Or finally, 3, the presence of hazardous substances or petroleum products in, on, or at the subject property under conditions that pose a material threat of a future release to the environment. Material threat, likely you can see that there's definitely subjectivity that comes into play when a consultant is preparing a Phase 1. Although I would say that it's a very large majority of the time when I'm reading another Phase 1 report, I'm in agreement with whether someone is saying an observation poses a likely threat of a release or not. Maybe that's a little bit. I might be on a little bit on the more optimistic side, but that's just my personal feeling. Likely, they define likely in the last update to the ASTM standard. that which is neither certain nor proved, but can be expected or believed to be believed by a reasonable observer based on logic and or experience of the environmental professional, and or available evidence as stated in the report to support the opinions given therein. I mean, just take a look at this definition of likely. It talks about the experience of the environmental professional. There are environmental professionals that have done thousands of phase ones. There are some that have done hundreds. There might be some that have only done 10 of them. So Jim recommended not just Googling to find an environmental consultant. And I agree with that statement 100%. And I thought this was something good to add at the bottom here. Studies done by the Environmental Protection Agency and others have estimated that 75% of the approximately 30,000 dry cleaners currently in operation have contamination. So certain things are obvious, like a paint manufacturing plant or even a gas station. Since small properties or retail strip malls that a layperson might think have very little environmental threats within them. You have to understand that if there is historic dry cleaning on a property, that should, in the eyes of the consultant, just based on the historic use, automatically be a recognized environmental condition. Material threat means obvious threat, which is likely to lead to a release, and that, in the opinion of the environmental professional, would likely result in an impact to public health or the environment. Here you see a picture of a 1,000-gallon oil tank that is in bad shape and poses a material threat. If this would be a new tank on supports, not sitting on the ground, could be inspected underneath to see if there's any rust, then that would not be a material threat. It would not be an REC. It would simply be a business environmental risk. But in the case of the photo here, this would constitute a material threat of a release. It's important to understand that there is a provision for de minimis conditions. And the standard states that de minimis conditions, like the ones you see here in this parking lot, which is really, really common, just to have small amounts of motor oil drip onto asphalt. These do not constitute recognized environmental conditions. Again, can be very subjective and left to the opinion of the environmental consultant. Jim provided these examples, and with underground storage tanks and buried materials, covering probably 90% of the RECs that we identified, or we are likely to identify in a phase 1 ESA. So there's also historical RECs and conditional RECs. I think these came around the 2008 revision to the standard. A lot of sites have had historical spills, but have been cleaned up. But they've been cleaned up in different ways. If a site in the past had a release of a hazardous substance or a petroleum product, and the cleanup was approved by the environmental agency, and it was cleaned up so that there are no restrictions on the property after that cleanup, then that's a historical REC or historical REC, and it's not a current REC. So this is not a ongoing concern. However, there's also something called a conditional REC. There was a previous release at the site, and the investigation and cleanup was approved by an environmental agency, but contaminations were allowed to remain in place. Typically, you'll have some kind of engineering control, maybe an asphalt cap or 2 feet of clean soil imported to cover up the contamination, but it's left in place. And because there's an engineering control that no one should be disturbing in the future, there's also an administrative control, what we call that under the ASTM standard activity and use limitations. And these are typically immortalized in an environmental easement in New York, in an environmental covenant in Pennsylvania. I forget what they call them in New Jersey off the top of my head. So these need to be brought out in the phase one report alongside the RECs. So it's possible that a report could have RECs, historical RECs, conditional RECs, and BERs. So they're basically that's it. Those are the four categories of findings in a phase one ESA. Vapor migration screening. This was introduced in the 2013 revision to the ASTM standards. Prior to that, we were not looking at the potential for migration of vapors onto a site from offsite, which is why sometimes we go back and look at an old phase one, and while that phase one concluded there were no recognized environmental conditions, today under the new standard, we have to conclude that this offsite gas station is an REC, and therefore we recommend a phase two to see if there's any vapors in the building or under the building on our site. This is so that doesn't mean we're actually doing the vapor sampling as part of the phase one. It simply means that we're looking at the potential for vapor migration onto the property, and if we believe there's enough potential, then we identify that as an REC. Phase one updates, phase one environmental site assessment reports do have a shelf life, and that shelf life is 180 days. If a phase one under the standard, if a phase one is more than 180 days old, we must update the interviews and the database searches and the visual inspection of the site. We provide a questionnaire to the user and the EP declaration of our opinions of the of whether there were any substantial data gaps and the information that was procured as part of preparing the phase one update. We have to work off of valid prior phase one ESA. Every now and then somebody actually has one from 1987, and chances are an old phase one ESA would not meet today's phase one standards, or we just unfortunately sometimes see phase ones that were done very poorly. And if that's the case, we have to say to our client, we're sorry, we cannot do a phase one update on this phase one. We have to start from scratch with a new phase one. These are not part of the ASTM scope. They're specifically called out in the ASTM standard that these are not part of the scope of a phase one, although there are lenders, and like I mentioned before, HUD or SBA might want us to look at some of these non-scope items and describe them in our phase one reports. Wetlands and endangered species, at the most, I believe if you're doing work for HUD, they just want you to look at national wetlands inventory maps, not actually go out and do a wetland investigation. Regulatory compliance, Jim mentioned before, a phase one is not a regulatory compliance audit. So sometimes in mergers and acquisitions, we're asked to do a phase one and an environmental compliance audit of a property or multiple properties. The people in our company that do environmental compliance audit are completely different than the scientists that go out and do phase ones. They are drastically different. We are not looking at compliance with the air quality, the Clean Air Act or the Clean Water Act or the Resource Conservation and Recovery Act. That is not part of the phase one. Industrial hygiene, health and safety is not part of the phase one. Asbestos, radon, lead-based paint. Sometimes we'll be asked to give general conclusions on the likelihood of these materials in a phase one. Also lead in drinking water and mold. Indoor air quality, we're typically not asked to evaluate that in a phase one. Now, some photos that common environmental conditions. What we have here are storage tank sites. And I'm going to say these are not going back 20, 30 years. These are in the last 10 years. On the left, you see one of our scientists pulling pure gasoline off the top of a water table from an active gas station. This is a convenience store gas station. So existing fully compliant storage tank systems still have leaks. It's important to know that. So if we're doing an evaluation of a gas station, we might recommend as part of the phase one, we go out there and at least observe the observation wells around the tank field. We might want to look at their compliance record for their storage tank system. On the right there, that pink colored material is diesel fuel. That's diesel fuel has the pink dye, and that tank was pulled about 10 years ago. And on this photo, you'll see a bunch of ancient tanks that were some of these photos are 30 years old. But we still see tanks being pulled out of the ground that are 50, 60, 70 years old that have resulted in contamination of underlying soils and groundwater. When our environmental scientists are going out to do an investigation, it's very much the work of a detective. You need to know the difference between a tank fill cap. Underground storage tanks, or USTs, are very common environmental concerns. And so you need to be able to determine the difference between a gas tank fill cap and a natural gas valve or a sewer clean out. So these are things that our staff are very well trained to identify when they're walking through the field. Remnants of former fuel pumps, even a certain type of shape crack in asphalt can lead you to conclude that there was once a gas station on this property. Staining, obviously, it jumps out at you. It's easily visible from the surface, but then again, there's that subjectivity and the conclusion of the environmental professional: is this de minimis or is this an environmental condition? And here's a couple of examples of waste dumps and fill areas, even at farm properties. I mean, I don't think I've ever seen a farm that didn't have at least one small dump area. And if it's just domestic debris, that's great. But every now and then they throw an old pesticide can in there or an oil can, and then they can be issues, probably relatively small issues, but they can be issues. That's the phase one ESA discussion. We're going to go into a discussion of now what we do when we do a phase two investigation. And Diana, I don't know if you wanted to pause now and provide a code word to the audience.
You read my mind. The second code for today is remediation. The second code for today is remediation. I will type it in the chat. Thank you.
All right. Thanks, Diana. So a phase two environmental investigation could include generally up to 4 things: geophysics, soil sampling, soil vapor sampling, or groundwater sampling. We're going to go into each of those a little bit. Let me check my time. Looks like we're doing pretty well. Yeah, geophysics surveys are non-invasive. You see that person on the top right there? She's walking across the surface of the ground with, I'm not sure if that's ground penetrating radar or if it's an electromagnetic device, but there are a number of tools that we can use to identify anomalies under the ground. And these are done by specialists. We call them geophysicists. They're skilled at performing these surveys and interpreting the results that they see on the screen, like the one you see in the slide here. Water line, sewer line, and then this one, this anomaly that looks just like a curve to us is indicative of an underground storage tank. And then there's the intrusive investigations. There's a tool that was developed about 30 years ago called a geoprobe. It's a hydraulically pushed device that comes in various sizes, from handheld to small dollies to very large track rigs. And these are what we use almost all the time when we're going out to collect soil samples. And these pull nice cores out of the ground, like you see on the right side here. And our scientists will use field screening tools. We'll record the type of material. We'll see if there's any imported fill, unnatural material in there, cobbles, not cobbles, but slag, coal ash, things like that. And then we'll collect our samples, put them in the appropriate bottleware, and send them to a laboratory for analysis. And then conventional well drilling, sometimes we have no choice if we have to get down through bedrock to get into groundwater to bring out the large, noisy, dusty rigs like you see on these two sites. On the left is
Jim, could I just
Yes.
add can you go back to the prior slide?
Absolutely.
Thank you. Am I correct that you're keeping track of the depth from which the sample was taken? So
Yeah.
can you explain that and why that's
Yeah.
helpful?
Yeah. We prepare a log for each boring, a graphical log, and it shows from top to bottom the material that we encountered. Some of the notes will be like blackish gray sand and ash, and then below that, it might be reddish brown silty clay, and then they'll indicate whether there's any kind of gravel in it. So yeah, our typically it's a trained geologist going out to conduct these investigations, and they for each boring that goes in, there's a one-page log describing our observations.
Thank you.
Sure. And I mentioned also soil gas. So we go out there and again, we're drilling through floors. So soil gas can be deep underground, 5, 10, 20 feet, or many times we're just trying to see if what the soil gas is like directly under the slab of the building. And if you look at the right there, these two canisters are called SUMA canisters. They're preset by the laboratory with a vacuum. We drill into the slab. There's a tube that goes from the SUMA canister to the hole in the slab. They're both sealed. We open the valve, and over time, 2 hours, 8 hours, 24 hours, depending on the type of sample we're collecting, this will collect a sample of soil gas. And states have cleanup levels for soil gas, just like they have for soil and groundwater. So we're comparing all this data to typically state regulatory action levels to determine whether there is contamination. If there's contamination, is it below or above certain action levels? And states have different action levels for unrestricted use, or residential, or commercial, or industrial. So that's why, and I don't have this on a slide, but I think thinking about it now, I should add it, that the future use of the property is important for us to know when we're doing a phase one, because that could be the difference of whether something is an REC or not an REC, or whether it's a high risk REC or a relatively low risk REC. That concludes a description of what we do when we're out in the field doing phase twos. And like I mentioned, I wanted to talk about something that's unique to New York City. I don't know of any other city in the country that has its own cleanup program. But New York City has something that grew from the massive rezoning that started occurring in the city maybe 20 years ago, because there was a shortage of properties that were zoned for residential, and the city wanted to allow formerly commercial and industrial zoned property to allow their redevelopment for residential use. And so they came up with the E designation program, and the E designation, it's a zoning map designation that indicates that there's the presence of environmental requirements. Okay, it doesn't say that there's contamination on a parcel. It means there's a city requirement pertaining to one or more of three things: hazardous materials contamination, noise attenuation, and air quality impacts. And they're established by the Department of City Planning with the assistance of New York City Department of Environmental Protection. So in general, before any new construction or change in land use can take place on a property that has an E designation, the requirements of the designation need to be satisfied. So these have to happen. This needs to be started early on in the investigation and feasibility study and design phase of a new construction or alteration project. And so the City Environmental Quality Review Office will issue these letters, and this is hard to read, but these are letters that are issued as part of a neighborhood rezoning that will say, we are putting on this block and this lot an E designation for hazardous materials and or air quality and or noise. So how do you find out if a property has an E designation? There's actually a couple city websites that have this information. I think it's called the Building Information System website, the BIS. I think the architects typically will use that. But New York City also has SPEED. And this is the Office of Environmental Remediation. So this is the website that I typically use. But you can go on, you can put in the block and lot, you can put in the street address, and it will tell you if your site, and in the case of what you're seeing here on your screen, that's the site that's outlined in red and filled in with pink. That's our site. And you can see that it has an E designation, and then it also shows you E designations in the area. If you click on that E, it will tell you what the seeker number is, the City Environmental Quality Review number is, so that you can actually pull up that seeker document and review it. And also it will tell you if it has one or two or all three of the E designations. So there are great online tools. Fortunately, there's also a portal for any reports that are prepared and submitted to OER. So investigation reports, cleanup reports. There is now an online portal for all of the work done under the city's E designation program, which is a great tool. The E designation program, like I said, this is a mandatory program. This is not a voluntary cleanup program. If your site's got an E designation, you've got to follow this pathway. You've got to do a phase one. You've got to prepare a phase two work plan. You don't get out of a phase two if you have an E designation, by the way. There's no bargaining with OER. There's no negotiation. You'll work with them on developing a scope of work for your phase two. You'll do your phase two. If everything's clean, that's fine, you're done. But most of the time, you've got at least some residual material, like some historic fill, that's going to need to be addressed when the site's being redeveloped. If a site is not being redeveloped, let's just say you're doing a building renovation, that you're not forced to go in and clean up soil. You're not forced to go in and clean up residual groundwater contamination, but you may have to go in and put in some kind of system to prevent vapor intrusion into the building. So that's something important to know. If you're going to go in and put in a new building with a 20-foot deep basement, yeah, you're going to excavate all that soil and it's going to be properly disposed. But if it's a small renovation project, just because you find soil contamination doesn't mean it has now turned into a soil remediation project. Want to make that clear. And we were talking about activity and use limitations before in my phase one slides, and the potential to have to put an environmental easement on a property. You wouldn't normally need to do that under the E designation program, because that E designation really serves as your administrative control, as your activity and use limitation. That's what I really like about the E designation program. It eliminates one obligation to put a a restriction on a property, it's kind of built in to the program. There is also a voluntary cleanup program, which I would, if you don't have an E designation, but identify contamination on your property and want to get a release of liability, or want to take advantage of other nice nice opportunities to get some grants or to save money on soil disposal, then you can, whether you're an E designation site or not, you can opt into the voluntary cleanup program. The cost to enter is a couple $1,000s, and a lot of times you can get $25,000 or $35,000 in brownfield incentive grants from the city. So it pays for itself. That might not be a lot of money for a large project. For a small project, a developer might be very appreciative of those funds.
Jim, can I throw in a couple of things here?
Absolutely.
Yeah. So thank you for mentioning this. It was beyond the scope of the program overall to go into ways of cleaning up. Otherwise, I would have something about the state brownfield cleanup program.
Right.
But a couple of things. One is that the liability protection isn't just from one state agency, the New York State Department of Environmental Conservation, and maybe Jim didn't really mean to limit it. The liability protection is from the state of New York. And the reason that's important is that you also have this other agency, the Department of Health, the State Department of Health, and you wouldn't want a liability protection just from one state agency when there's another one, distinct, separate and distinct, that has distinct responsibilities. So the release is from New York State. The other thing important to note is that once you have some data on how much contamination you have on property, that may help guide you as to whether you want to go into the state program, or if the contamination is relatively minor, you'll be steered by the state, or you yourself can save time and just go directly to the city of New York. They won't handle, and if you go to the city of New York directly and the city looks at the data, they might say, gosh, this is a little more contaminated than we handle. Go to the state and enter the brownfields program. So there's sort of two different roads to take on that, each with their advantages and disadvantages, but it may be determined in advance by the level of contamination you have on the property, whether you can go into the city's voluntary cleanup program or the state's brownfield cleanup program. And that's all.
I'm going to add a slide, Jim. Yeah,
sure.
It's a good point.
Sorry.
Because no, I don't. I'm going to add a slide, but I want to tell everyone that what's great about the New York City Voluntary Cleanup Program is if you're in it, you don't have to work with the DEC at all. You're still just working with New York City OER. And how do they do that? Because they have a memorandum of agreement, and they meet. Every 2 weeks, OER and DEC get on a call and they discuss all their sites. And this is important to note because if the state during those calls looks at the data and they're concerned and they'll call it what they consider a significant threat, they can take the site over. And you then have an option of being in the state Superfund program or entering the New York State Brownfield Cleanup Program, which is a voluntary program. So, correct, Jim?
Yes.
Yeah. So I'm going to add a slide for the next time I get this. Anyway, here's a graphical depiction of all the areas that have been rezoned, and this is probably 5 years old. So the shaded areas will probably be even larger than what I'm showing here. Just to give you an idea that these E designation sites are all over the city throughout all 5 boroughs. I mentioned before also that there is a lot of information that the city has on an online portal. The documents are uploaded to this portal. They're saved there forever, and it's a great tool for environmental consultants, but even environmental attorneys that might want to go in and do their own research and find reports on a site or on an adjoining site. It's really nice that all is available, and you can see this in this lower part, the center here. These are all um, reports that are available for downloading on a particular cleanup site that's been completed, whether it's in progress or completed. Whatever reports the OER has will appear on the Epic website. And I also want to mention, I mentioned before, but if you enter the VCP, whether you're an e-designation site or you're not, and you just voluntarily enter the VCP that the city has, you can have brownfield incentive grants. They could be $25,000, $35,000, $45,000, depending on the nature of your site, where it's located, and what cleanup standard you choose. A very large percent of contaminated soil that is excavated at a cleanup site does not reach the level of being a hazardous waste. But once it is, it can be enormously expensive to dispose of. If you have any soil on your site that is hazardous waste, the state's fees, which are very high, are taken out completely, and the city just adds a $10 a ton fee, which is insignificant compared to the state's fees. Again, the liability protection, you could get a green property certification with a nice green plaque to put on your building. And I think I'm going to say on some sites, the most financial benefit you can get from entering the VCP is being able to use the city's clean soil bank. The city has a site in Brooklyn that has an enormous stockpile of clean soil that people have excavated from sites. They didn't want to pay $50 a ton to send it to a clean fill site in New Jersey or Pennsylvania. So the city will require testing, confirm that it's clean fill, and keep it in their stockpile in Brooklyn. So if you need clean soil at your site, you can get that for free and just pay for for trucking. Or if you're generating clean soil, you can do the appropriate testing and send it to the city's clean fill bank. And again, only pay for trucking and not have to pay a huge tipping fee at a landfill or a reclamation site. So that could be a really big financial benefit. And if you meet a certain cleanup level, you can have a hazmat E designation removed from a property. Here, if you go through the VCP, this is an example of the green property certification that you can get. This is just an example, a pictorial example of going through the clean soil bank. You got your brown layer there that's from the top. That has to go to a licensed facility for disposal. But if you're going down 20 feet or 25 feet because you're putting in a 2-level underground garage, you've got all of this actually good quality soil. You can send it to the clean soil bank and not pay high disposal costs.
Jim, I just thought of a catchy phrase you can use with clients when you talk about the clean soil bank. Only pay for what you need. Liberty, liberty, liberty. Perfect for you guys.
Yeah, I'll add that. Okay, and here's an example of some of the brownfield incentive grants. Unless you are, there's an exemption here. If you're south of 96th Street in Manhattan, or if you're over 100,000 square feet, if you're a really large project, you can't get any of the BIG money. But for smaller projects and those not below 96th Street in Manhattan, you could get at least 25,000 and up. Here's the exclusions, and this is the fee exemptions. These fees are huge. Like I said, $130 a ton, $27 a ton. That you're paying $500 a ton sometimes to get rid of hazardous waste soil in New York State. The New York State basically doubles the cost of disposal of hazardous waste. So you're saving $157 a ton and paying the city $10 a ton. So it's a great deal. And that brings me to the end of my presentation.
Thank you both so much for a great presentation. I just had 2 questions. I will send them to you guys directly in an interest of ending on time. I'm just going to put them in my chat.
And Diana, maybe you could...
Thank you both for a wonderful presentation. It was a pleasure to have you. Next month, we are going to be doing a 1 credit ethics course, and you should see that coming out soon. Did you have anything to add?
No,
Jim?
I was just going to say, Jim's last slide had his email address, and my slides were so long ago, you might just give them my email address if they have any questions about the presentation. My first initial and last name, J. Periconi at periconi.com. Easy to remember. If you have any questions, happy to answer.
What I'll do is after this, once we end this afternoon, I'm going to resend everyone the affirmation material evaluation just in case you did not get it. And I will add your contact information onto the slides for you. Thanks again, everyone, for coming. Thank you guys for a wonderful CLE.
Thank you.
Thanks, Diana.
Have a great day, everyone.